As many privacy pros are aware, one of the CCPA, California Consumer Privacy Act requirements is to provide the do not sell or share personal data link. However, what does selling or sharing really mean? We are going to nail down the sale or sharing of personal data in less than 5 minutes. However, before we start, I would like to show you this visual. Please take a moment and review this graphic for 15 seconds. If you understand what it means, then I would like to save you a few minutes. You don't have to watch the rest of the video. But if the picture is still not clear in your head and you need to digest it further, then you can keep watching and see how I break down these two terms. I will also need to make a clarification. Although many people call out the CPRA, Consumer Privacy Rights Act, as if it is a separate regulation, it is in fact just an amendment to the CCPA. Therefore, they are not two different privacy laws. It is only one, and it is the CCPA. Why does that matter? Because the CPRA is an upgrade to the CCPA, and after this upgrade, many provisions and definitions in the CCPA have changed, and some new terms were introduced, and selling and sharing personal data were among those definitions. Before the CPRA update, the CCPA did not have a definition for data sharing. Similarly, before the CPRA update, consumers did not have the right to opt out of their data being shared. Therefore, it is important to know that data sharing was added to the law due to a necessity. Now let's get back to the terms themselves. The CCPA broadly defines the term sell to include any arrangement involving an exchange of value between the business and a third party or another company for consumers' personal information. Within the context of the CCPA, the definition of selling has 3 elements: communicating a consumer's personal information to a third party and for valuable consideration. The types of communication of personal information include selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating. As you can see, it is a catch-all term for disclosing data. The second element, a third party, under the CCPA is defined as anyone other than the business. However, contractors or service providers are exempted from the definition of a third party. An important thing to note is that service providers need to be restricted with a contract, because if they process data outside the scope of providing their services, it will qualify them as third parties, and they will also be subject to the opt-out requirements for selling data. Finally, consideration, it is a contract law term and might take hours for me to explain it here. However, long story short, a consideration is a thing for which a contract's object, in this case personal information, is exchanged. The important point from this definition is that you don't need to be receiving money in exchange for personal information in order to sell it. If you are sharing personal information in return for a product, service, or anything else that benefits your business, then you are selling data. Despite its broad scope, the CCPA's sale of data definition left some vague interpretations, and there were situations you would argue the existence of a valuable consideration. This led many companies to continue their cross-contextual behavioral advertising, especially for cookie practices. As a result, some businesses were collecting consumer information by taking advantage of the vague definition of data selling, while others were asking for opt-in consent when it may not have been necessary. Therefore, with the CPRA update, the CCPA included a new term, data sharing. You should keep in mind that data sharing is a technical term. It is not defined as simple as the transfer of data between two different entities. Therefore, you have to be careful with using the term data sharing. Within the context of the CCPA, data sharing has 4 elements: communicating a person's information to a third party with or without valuable consideration, and for cross-context behavioral advertising. As you can see, sharing has the same 2 elements as selling. However, in addition to the definition of sale, the definition of sharing is limited to cross-context behavioral advertising and can be made with or without valuable consideration. As a result, the term data sharing is actually used to describe data transfers for cross-context advertising. If it is with a valuable consideration, then it will also qualify as data selling. If no valuable consideration, then it is just data sharing. So after breaking down the definitions of selling and sharing data, please take a look at our visual again. As you can see, the first layer of the graphic is communicating the data. And under that, we have data sharing and data selling circles. Data sharing is limited to cross-context behavioral advertising, and data selling is limited to the existence of a valuable consideration. We have a joint area where communicating the data to a third party could fall under both data sharing and data selling. And there are scenarios where a business can sell but not share the data, or vice versa. I hope this removes the ambiguity of these 2 definitions for you, and I hope you have enjoyed watching this video. Please don't forget to hit the like button if you did, and I will see you next time.